First things first, this video is not legal advice. Nothing in this video should be construed as legal advice. This is all for educational and entertainment purposes only. Okay, I am thankfully not a bar attorney. This is not an offer to be your attorney. Keep that in mind as we produce and continue with this video.
Hello, I'm going live on both this platform here on Facebook as well as TikTok. So if you see me doing like this here, I'm talking to both, okay? The agenda today is going over administrative adjudication versus Article 3 judicial process. In this last week, I assigned the Treasury their fiduciary responsibility to administer the account or the ens legis name as the principal, right? So they created this account thing that is the assignment of fiduciary duties. We want to be self-governing, but we're given this account thing and we're limited with it, right? Because it's their number, it's their name, it's their like estate thing that they created, right? And it looks very similar. It's not styled the same, and by styling I mean that it's written in all capitalized letters, right? Denoting that it is a corporation. This corporation was created by the other people, right? The United States corporation, right? So it's an extension of the Treasury ultimately, okay? And so what we're trying to do then is if it's theirs, then we need to, allow them to be the principal. And of course the principal is liable before the surety. If you don't know what that means, we need to study what suretyship is, and that is just like essentially who is the liable party for a debt. And a debt is sometimes noted as what they are charging us with a crime, okay? And so a crime is a banking instrument or a debt, okay? All crimes are commercial, maybe you've heard that. I don't believe all of them, but there is ones that are commercial, right? They've largely taken our rights, converted them into crimes so that they can generate revenue. And the reason this is affecting us is because we have waived our rights in exchange for benefits and privileges through adhesion contracts when we signed up to get a state-issued driver's license or identification card, right? We sign. We don't even offer our autograph in ink anymore. It's on like a little like electronic signature pad, right? And so they're able to upload this signature to all kinds of clauses and things on the back end, and these are called adhesion contracts. Well, now for a contract to be valid, there needs to be the meeting of the minds. Two people who are coming together, and there would be a meeting of the minds, meaning two competent people. It's a bilateral contract, okay? And so that's lacking. Really what's happening with the state issue identification or driver's license is it's just an agreement. We're agreeing openly to whatever they want to apply that signature to. And so we're just saying, yeah, okay, well, here's my constitutional rights. I agree that you can govern me. And I'm waiving all of my constitutional rights, and I am hereby admitting that I am a government agent and a government employee, so I'm happy to allow you to regulate my behavior because, hey, I work for the government, right? And so I get this driver's license, and I've never been paid for driving from the state, ever, right? But yet they're saying that I'm driving, right? Which is a commercial behavior. And so what's going on there? Okay, so we're going to come back to the concept of driving, but we're kind of understanding what suretyship is in a high level here, which is we are the co-signer for the liabilities of the principal. And because we haven't said, hey, the principal needs to be liable before me, they are coming after us for the liability. So like, let's think of a loan, right? I don't qualify to get this loan somehow, right? Let's not get into that for a moment, but sometimes they say we don't qualify to get this loan. And so we need what's called a co-signer. And this co-signer steps in and they're offering themselves as surety, meaning another liable party if there is a default from the principal. which would be supposedly the person signing first, right? So the principal is the first original liable party, and then the surety is somebody else that is a liable party to this supposed debt that happens, okay? So that's what's happening with our accounts. The original debtor, the principal debtor, is the Treasury, the United States. That's the principal obligor of all debts, public and private, okay? And what they're doing is they are asserting that we are the surety, and we are behaving as surety for free, because equity doesn't aid a volunteer. And so we are just like, hey, yeah, I am happy to go to bat for you, and I will behave as the liable party. And the Treasury views this as like, okay, cool. You want to do that? You want to volunteer to do that? Go right ahead. We're not going to stand in your way. And so how do we correct this? Is we need to assign fiduciary duty to the treasurer, to the principal, right? So what I'm doing is I'm saying, hey, actually, this isn't right. You actually hold the liability for everything. I've been stepping in this whole time in error, and I didn't mean to be doing that. I was too stupid at the time, right? And so I'm admitting, like, hey, I've been sinning this whole time. I've been admitting, that I'm the surety here, and I didn't mean to be doing that. My bad. You're actually the liable party. Please do your duty and handle all of the debts, all of the records, all of the things, all of the court cases, all of every single thing, all of the things on the ledger that are yours, and handle them from now on as well. Okay, I don't want to ever see another presentment. And if I do, I'm going to give it to you. But because I do not want to be your trustee, I am the beneficiary. You are hereby on notice that your fiduciary responsibilities are yours. I don't want to behave as a trustee. In other words, all of these presentments better go to you from now on and not me. I don't want to touch another presentment, meaning Bill. Right? I want them to go to you. I want you to handle all of it, and I want you to, I just want to be the beneficiary as was designed. That's what you're saying, and I know it sounds very like woo-woo, or like, okay, yeah, what? You're just gonna have the Treasury like adopt all of your responsibilities? Well, and they're actually, again, they are the responsible party. They have allowed us to believe that we are the responsible party, and so we've been behaving as a trustee in error. We're the surety in error, essentially. And so we're just saying, hey, I don't want to be. If I am going to be your surety, you're going to pay me, okay? And okay, Derek is calling me. Let me see. I don't know that I can. I'll try it. Okay. Okay. It's loading. Something's happening. Okay, I'm hoping that this works. Okay, give me a second. Okay. Oh, I'm sorry. I don't think that's going to work. Okay, so back to it though. We are assigning fiduciary interest to those things, right? We're going to come back to assignment and the Universal Declaration and the affidavit and notice that I had sent just this week, and who I sent it to, and all of that. What I want to talk about right now is addressing the adjudication of courts, and why and how that is the way that it is. Okay, and so I'm actually going to. How do I do this? Settings. Stream. There's got to be a way for me to show my screen. Okay, camera controls, default, what's this? Okay, sharing, start screen share. No, I can't, I guess. Okay, so the interface on Facebook is completely and entirely limited, and it's very frustrating, and that's too bad. Okay, so I can't actually show what I wanted to show, so I'll just explain to you then that it is this certain way, okay? Essentially, there's Article 3 courts, which is the the true way of judicial system. Okay, and so Congress can only delegate the authority that it was given by the grantors of the charter, which is us. And so it can't delegate judicial authority because it never had judicial authority. And so all it can do is delegate administrative, legislative ability. And it can't even do that. It can only delegate administrative authority as it pertains to the legislation that it creates. What does that mean? It means that the administrative courts that it has set up for its own administrative Article 1, that's the legislative courts, these administrative court judges, these administrative law judges, only have been delegated the authority of the limited capacity of an administrator by Congress, and they cannot actually be judicial officers because Congress can't grant that, right? So the Article 3 of the judicial branch, that is the capacity that they were given. And what exactly does that mean? Were the judges given that authority? Well, actually, no. The courts themselves were. And so when you see an order signed by district judge or signed by judge, right? The judge is signing an order in an administrative law capacity. So the court itself actually has the ability to make a lawful order, not a judge. And so largely every order I've ever seen is an illegal order because they're signing outside of the capacity of the court. Unless they are signing on behalf of the court, they are not giving what is a lawful order. It's an administrative order that applies in administrative hearings and commerce. And so when we're bringing up constitutional arguments in an administrative environment, what they're doing is they're taking off this hat and they're putting on this other hat, okay? And that hat is the capacity of an administrator or also an mediator. So they're just stopping, they're suspending any actual court, and they are becoming an arbitrator or a mediator in an administrative commercial hearing. So that's why they can just let you speak, and they don't even hear what you're saying, and then they just pick up right where they left off, because they're only in the capacity of a mediator, and they're not actually being a judge at that time. They're not actually operating in the capacity of a court at that time. And so, yes, it's frightening, right? But there is an executive order from the current administration that acknowledges the capacity and the limitations of such administrative law judges and what is and isn't protected, right? And I've been made aware that they had until April 18th to correct their behavior and capacity from an administrative law judge to being an Article 3 judge. But their protection at this point has run out. Okay, and so they're not protected, or they have no immunity. Excuse me. So that's what's happening in these courts when we're not getting heard. They don't hear you because you're living, and they can only hear the dead, and blah blah blah. Right? They're not hearing us because they're not holding court. They're in basketball court, and we showed up with a tennis racket and a tennis ball. And we can play as amazing as possible a game of tennis, but they're in a basketball court. And so we're like, well, why am I not getting remedy? Why is this not happening? How come you can't hear me? I am alive. Hello, look, I brought the birth certificate. Look, I've done all the things. I did the filing, right? Why? What's going on here? Okay, and so what's happening is they are in arbitration and mediation, and they're signing orders on that basis. And so how do we address this? What's the remedy there? We would need to file what's called a motion to stay proceedings pending amended complaint, or pending amended motion to vacate judgment, or pending amended motion to dismiss, or pending amended. Okay, and so then we file our amended motion, where we're saying, hey, you never told me the nature and cause of this action being administrative and arbitration and mediation. Okay, and so this actually doesn't have jurisdiction over me because I am not one of your employees. Okay, and so it's it's not like it doesn't apply to me. Okay, and so the jurisdiction is hereby challenged. And again, that process is a motion to stay proceedings pending the amended motion for dismissal, or amended, motion to vacate judgment in my specific case, or amended complaint if you're the plaintiff, right? And you're saying, hi, you never gave me the nature and cause of this action, and you never fully disclosed to me that this is a mediation, this is an arbitration, or that this is not a court of law, and I needed to know that, and I've been behaving thinking that this is a court of law, and of course you're winning because you never told me that we're playing basketball, and I can't tell that we're playing basketball because you're dressed up like tennis players, but you're playing basketball. That's not really that fair, is it? And so it's not a court of record. And when we're trying to preserve everything for appeal, we're playing a different game. And so that is the sort of alarming me, raising the alarm, like, oh no, what's happening? What's happening is they are converting their capacity without our knowledge or consent to that of an arbitrator or a mediator, and then they're signing in that capacity as well, letting us believe and behave as though we're playing tennis, as though we are in a court of law, as though we are in the judicial branch before a judicial court of record, when really it is an administrative law court that is only, they're changing jurisdictions. Thank you, Derek. So they're without our knowledge or consent. And so remedy looks like motion to stay proceedings pending amended whatever thing that it is that we need to file, and then we amend it and we challenge the jurisdiction at that point, right? And then also, if we wanted to object at any given time in these cases, we could object saying the same thing. Hey, I object. What the hell is going on here? Like, I object. Did we just change? I need you to clarify the jurisdiction here. This case can't move forward until I know the nature and cause of these proceedings. And it seems to me that these are administrative, arbitration, and mediation. And I need to see that you're actually acting in capacity of the court, not as not in the capacity of a judge on vacation, or not in the capacity of an administrator, or not in the capacity of a mediator. Okay, so that is the nature of what we were talking about for adjudication, administration, that whole kind of thing. So I hope that makes sense. Please comment or what you need to on that regard. Now I am going to open up and talk about the Universal Declaration that I had filed. But first, I want to show you again here my reply brief in my current court case. Now, the opposition filed a motion to strike, and I believe it's because I included in Section 5 suretyship, and entity misidentification, and trust interest. And I'll just read it out to you what I had said. Now, under North Dakota Century Code, Section 22-01-03, the liability of a surety is secondary and arises only upon the default of the principal. And in this matter, the principal obligor is the United States, and this position is supported by House Joint Resolution 192, right, and which has suspended the gold standard and obligated the United States to discharge all public and private debts using legal tender. Now, the Federal Reserve notes are declared obligations of the United States under the Federal Reserve Act, and their legal status is further affirmed in Public Law 97-258. Since legal tender in the United States consists solely of instruments backed by the federal government, and since no party can demand lawful payment payment in lawful money such as gold or silver, the United States stands by necessity and operation of law as the principal obligor in all commercial debt matters settled using its monetary instruments. And plaintiff has provided no evidence, because I'm the defendant in this totally bullshit case. Plaintiff has provided no evidence that the United States as principal defaulted prior to enforcement against me, the defendant, in error, right? The supposed surety. Okay, and so I am challenging that they went after the surety before they even proved that that they defaulted. So defendant holds interest in the legal name, right, as beneficiary and implied surety, and this improper order of liability where enforcement was directed against surety absent default by the principal constitutes a fundamental breach of equity and commercial law and further undermines the legitimacy of plaintiff's action and the garnishment that follows. Okay, now that I hope that was, you could understand what happened there. Now, I do want to mention also the preservation of the commercial discharge facts. Now, this was the plaintiff's opposition fails to address the post-judgment actions because they rendered a judgment, right, against me, which is why I have a motion to vacate judgment. So the plaintiff opposition fails to address the post-judgment actions that the defendant, I, took relevant to the enforcement of the debt. These include material facts related to good faith commercial discharge efforts and correspondence with both Capital One and the United States Treasury. So what I did was I tendered all of the supposed statements, account statements, and I endorsed them, and I stamped them, and I sent them to the IRS, who then tendered to me an IRS payment voucher. Now, I endorsed that payment voucher to the CFO, Andrew Young, of the umbrella corporation of Capital One. And then I also assigned fiduciary responsibility for this debt to the United States Treasury, and I have record of everything I just said. And I entered it into exhibits in this case. And I said, hey, after you gave judgment, I did tender an equitable good faith payment to make good on this, even though it was under protest. I did it and so that you wouldn't garnish me. Okay? And the plaintiff went ahead and garnished anyway. And so we have these facts are preserved here and expanded upon in the accompanying declaration and are included as exhibits 10, 11, whatever, so I included the exhibits. And then the response from opposition was to motion to strike. I haven't even seen the substance of that motion yet, but I am certain it has something to do with everything I've mentioned here today, okay? And so I'm in an active court case attempting to set precedents for this whole situation, and I'm prepared to go to the United States Supreme Court, just like one of our members here in the Lamb's Reckoning, who is going to the Supreme Court against certain entities here in North Dakota who have proven that they have no interest in abiding by the law as is written, and so they're plainly doing unconstitutional behavior and depriving us of our rights to life, liberty, the pursuit of happiness, etc. So he's going to the Supreme Court, and my case is pertinent to that. This exact case is in a way pertinent. Now I have another case that's coming up, but yes, the Job Service of North Dakota is not operating in good faith. So, and that's that one. But my point is, with this particular situation, I'm happy to go as far as the Supreme Court, and this is what I'm talking about. They are skipping over commercial due process, as well as they're plainly in violation of what is their statutory law, as well as what's supposed to happen in commercial liability order. Right, the principal has to be held liable before the surety, and they never proved that that the United States defaulted before they came after me. This is happening to everybody, right? With mortgages and foreclosures and all kinds of stuff, right? So this is precedence for everybody. Like, there's so much going on in the country anyway, so that's why this is important. Now, I'm going to talk about now the assignment that I did this week, and so that's highlighting how they are not being lawful judicial officers. They are just going into arbitration and being mediators and signing in the capacity and creating unlawful orders. Okay, so that is how it's personally relatable to me. Now, what happened in my Universal Declaration is right here. Give me just a moment. So, Universal Declaration. Now, I know that I had said certain things in that. Now, I'm going to actually open it up on this computer. So give me just a moment here. Okay. So sorry. So now I'm going to tell about and Derek, I'll talk about subrogation again maybe another time. I think that's just a bit much for anybody listening in at the moment, and I could be wrong, but I think that there's just that's a little much. Okay, so my Universal Declaration, I'm going to read the whole thing. Okay, and it's going to be it's okay. So I'm just going to read it until I get banned on TikTok or Facebook, right? So I'm going to read it, and I'm happy to help anybody craft their own. But here it goes. So here's what I hand wrote, and I sent to the. Oops, here. Let me actually describe who I sent it to again. Just a moment. Okay, so I sent it to the Attorney General of the United States, Pam Bondi. I sent it to the Clerk of the United States Supreme Court, Scott S. Harris. I sent it to the General Counsel of the Federal Reserve Board, Mark E. Vanderweide. And then I sent it to the United States Secretary of Treasury, Scott Bessent. And like notice to principal is notice to agent and vice versa, right? So I've just kind of put the whole works on notice. Okay? And here's what I did. I sent in a universal declaration of status, trust, and assignment, and I backed that up with notice in the form of an affidavit. Okay? And so I'm going to read those both to you right now. So here it is. Let it be known under full capacity and in accordance with Yahuwah's exclusive equity jurisprudence through his word, and I hand wrote these things. So from my own hand. And I sent them all, okay? I did make copies, but I kept the original handwritten for myself, and I made copies, and then I signed it in wet ink on there, and I gave my thumbprint, and so that is how I established who the hell is talking to who here. And I told you who I sent it to, okay? So here it is. So let it be known under full capacity and in accordance with Yahuwah's exclusive equity jurisprudence through his word, the scriptures of the Bible, and the laws of equity of 1776 of the United States of America under judicial power and inherited civilian due process protections. This declaration is issued by the living man known as Andrew Strand, beneficiary of the foreign irrevocable trust known as the trust that I have. I don't need to tell you that right now. The instrument constitutes a full, lawful, and irrevocable public record that the capitalized name is the legal property of the above referenced trust and is no longer under the presumed control of the United States, any of its subdivisions, or its corporate commercial interests. All public debts, obligations, or instruments issued in the name are now to be lawfully administered as trust property and are assigned to the United States Department of Treasury as fiduciary trustee for the settlement and discharge of all such presumed liabilities. So all rights are retained, no privileges are assumed, and no benefit is knowingly accepted under coercion or adhesion to the jurisdiction of the U.S. civil or statutory law. This declaration shall stand as lawful rebuttal to any and all presumption of suretyship, citizenship, or commercial liability imposed upon the living man. For the record, the undersigned has in the past received certain public benefits, including but not limited to assistance programs, out of necessity only, and has not as evidence of consent to be treated as a U.S. citizen, resident, or taxpayer. Any such benefit has been accepted strictly under protest, duress, and private trust necessity, without intent to waive any natural, Yahuwah given, or constitutional rights. Furthermore, the undersigned declares the intent to offset the entire ledger of all previous court cases, administrative rulings, or civil judgments issued under the name, and to clear the record of the legal fiction ens legis entirely. All such entries, being commercial in nature, are hereby subject to equity discharge, trust assignment, and full nullification through constructive trust administration and lawful assignment to the United States Treasury. For the avoidance of doubt, it is hereby declared that the undersigned shall henceforth be known and identified as Andrew. Anyhow, I merged the first and the middle name, and I will talk about how I, have an ongoing, how I'm addressing that. For all private, ecclesiastical, and trust-related purposes, the composite name, blank, 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 remains a trust-designated commercial instrument and is no longer recognized as the lawful expression of the living man. Now, the declarant is, Andrew Strand, a living man and equitable beneficiary, and I talk about, the trust and its associated 98, EIN number, and the subsidiary trust enterprise with its 99 EIN number, jurisdiction, equity, ecclesiastical, the Heavenly Father's law, and 1776 constitutional principles. And the declaration of ownership, the entity styled as all capitalized blank 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 name is hereby declared a trust instrument and legal fiction, property of the trust, and administered by the trust enterprise, with Andrew Strand as trustee only under necessity, not as a person, and it is not a person, this all capitalized name, resident or citizen of any incorporated jurisdiction, and any and all use of the all capitalized letters name in commerce or by government agencies is to be regarded as trust activity only, not personal representation or liability. Okay, and so the assignment of liabilities back to the Treasury, which is subsection 4, I'm happy to show you this document. I'll redact it and I'm happy to show you it all, right? I'm just reading it through, okay? So, all presumed debts, obligations, commercial instruments associated with the name are rejected as invalid without verified bilateral contract, reassigned to the United States Department of Treasury, held under constructive trust by the said agency, including the Office of the Secretary, the Bureau of the Fiscal Service, and all the subordinate agents and departments operating under the United States Treasury umbrella, who are hereby deemed as fiduciaries in equity. Subject to equitable discharge and set off under universal law, Yahuwah's law, and original trust principles, inclusive of all court cases, administrative rulings, citations, or civil judgments previously issued in the name, each of which is hereby set off, offset, and discharged from the commercial ledger and subject to final closure under lawful assignment to the U.S. Treasury. Future claims, debts, or attempts to collect on the all capitalized letters name shall be lawfully redirected to the fiduciary trustee, the United States Department of Treasury, Office of the Secretary. The final notice of standing is the undersigned does not now or has never consented to being a U.S. citizen, a surety, a resident, a taxpayer, or a debtor. All such statuses are hereby denied and lawfully rebutted. The living man operates solely as a beneficiary of the private trust estate and shall not be compelled into any contract or jurisdiction without express, knowing, and voluntary consent, which has not and shall not be given. Okay, in the contractual fee liability notice, let it be known that any individual, officer, corporation, entity, or principal who trespasses upon, misuses, or disregards the terms, stipulations, and lawful record established herein shall be subject to the express trust established schedule of fees enforceable under private trust jurisdiction and included in this mailing for reference. This includes, but is not limited to, the misuse or unauthorized reference to the name, attempts to impose liability upon the undersigned, and enforcement of any administrative, statutory, or corporate claims to the contrary of the terms of this declaration, and all violations are enforceable under contract, trust law, and equity doctrine. And so this I hereby do affirm and declare, right? All that is true. That is the Universal Declaration that I sent to those 4 entities. And I also sent this document, okay? This is the notice in the form of an affidavit. Okay? The name, the all capitalized letters name, is held in trust. Okay? It's recorded and administered under ecclesiastical and equity jurisdiction. The standing is pretty much just affirming everything I just said in a notice of affidavit form in case the declaration wasn't enough for them to get it straight. Okay? Now, that is how I put them all on notice. And if they infringe on that, now there is a basis of like, hey, I gave you notice at one point. So now we're talking fee schedule, and now you're infringing on the trust here. So that's how I've set this up. That's what I did. That's how I assigned. I did a universal declaration. And if I need to, I will go and sort of nickel and dime those entities that I need to nickel and dime, right? But that was the overarching umbrella notice that I gave. And then what I did this week in support of that is I sent notice, this is just typed up notice, to LexisNexis, Equifax Incorporated, Experian, TransUnion, as well as the Consumer Financial Protection Bureau. And what I specifically did is I sent it to not their dispute department, but their legal department. I'm done talking to their public-facing offices. I only communicate with people's legal department anymore because they don't nobody understands except for the lawyers, and so I only speak with their lawyers anymore because there is no way to actually communicate what I'm talking about, because they will not understand. They will just simply continue with their standard way of handling a dispute, which is, hey, you didn't prove who you are, or here's a stall tactic, or here's this or that, right? So I only talk with an entity's legal department from now on. Okay, and so what I did, here's an example. I sent one to, like, here's what I sent to LexisNexis, for example. Is hereby given lawful notice and demand for immediate and total correction of all records, data, summaries, identifiers, analytics, publications, or transmissions involving the name, right? All capitalized letters name, which is trust property lawfully recorded, right? And I show the publication because I lawfully recorded this in a newspaper. So the whole world has been given notice. There is no example, there is no basis for them to say, no, you didn't, because yes, I did. Okay, and it's like there is a UCC filing. There's no way, and so we're done playing the games. We're done playing the dispute games. I'm not disputing anymore. I'm now just saying, hey, here's your notice. If you want me to sue you, continue. If you don't, then do what I say. Okay? All right. So this is me saying this is your chance. Here you go, right? The undersigned is the living soul, the equitable beneficiary of the aforementioned trust. The name is not public domain, nor subject to your administrative use, sale, dissemination, or profiling. Your entity has engaged in unlawful aggregation, profiling, and third-party distribution of my trust estate information without consent, contract, or lawful authority. As a result of your actions, the undersigned has experienced denial of public necessities and employment access, unlawful assumptions of liability, data profiling inaccuracies, and materially harmed personal and trust interest, trespass upon private trust records and identity. Over the past 2 years, the undersigned has attempted in good faith to correct, dispute, and address the unauthorized data entries and presumption of liability reported under the all capitalized letters name. Multiple submissions were made to your agency, including copies of identification documents, passport, social security card, and utility bill, consistent with your stated requirements. Despite these efforts, your agency has repeatedly returned form responses stating the identity could not be verified, while continuing to report derogatory data and maintain unauthorized profiles in violation of private trust jurisdiction. This letter constitutes a final rebuttal to any such denial, as the documents herein are now served directly to your legal department and general counsel with full lawful authority under equity. The undersigned has published lawful public notice of status standing in private trust jurisdiction in a widely circulated Florida newspaper, identifying North Dakota as the lawful domicile. Said notice constitutes constructive notice to all agents, officers, and principals regarding the name and the status of as trust property. So lawful demand is hereby made for immediate and permanent removal of all records, identifiers, or trust-linked data associated with the all capitalized letters name. A cease and desist from all future data aggregation, sale, or transmission of the said name. Disclosure of all third parties who have accessed or received data linked to the all capitalized letters name in the past 7 years. Written confirmation of full data suppression and closure within 10 business days. A written offer of restitution or good faith remedy to address damages caused by misrepresentation, defamation, and commercial trespass. All violations of this notice are subject to the express trust established schedule of fees attached herefor and incorporated by reference. This includes unauthorized reporting, profiling, storage, and third-party distribution of data related to the all capitalized letters name. This record shall serve as a lawful and final cease and desist order under private trust jurisdiction and equity law. Any further use, reporting, profiling, transmission, enforcement, or misrepresentation involving the all capitalized letters name shall be considered willful trespass, fraud, and commercial injury. All actions or presumptions taken without verified bilateral contract, trust authorization, or lawful delegation shall trigger applicable liability under the trust schedule of fees attached and incorporated herein by reference. You are hereby ordered to immediately cease and desist all such unauthorized activity. Failure to comply within 10 days of receipt constitutes commercial agreement by acquiescence and liability and equity. You are operating under strict liability. Continued inaction constitutes willful injury, fraud, and bad faith in commerce. This notice is issued under lawful standing, equity, jurisdiction, and by right of trust and inheritance. No statute, license, or corporate policy overrides the lawful record already recorded and declared. So failure to comply may result in lawful action under trust enforcement and commercial liability doctrines. So that's what was sent to the entity known as LexisNexis. Okay, and so that's how I put them on notice, right? And I did a certificate of service, and I sent something very similar to all of the credit reporting agencies. Okay, so that's how I handled the trust assignment and like fiduciary obligations and putting everybody on notice. And I hand wrote the first two things, and I sent them to those four. The Attorney General, the Clerk of the United States Supreme Court, the General Counsel of the Federal Reserve Board, and the United States Secretary of Treasury. I handwrote those, and I included those as elements that I sent in the notice to all of the credit reporting agencies, the Consumer Financial Protection Bureau, and as well as LexisNexis. Okay, and so that's how I handled the declaration of status, trust, and assignment. Now, people are curious, well, what did you do for travel? Well, I'm glad you asked. So I got a United States Department of Transportation number, and it's for private travel. So I'm traveling privately. I use this thing, and I got a license plate that says the number on there, right? So what did I do from that point? Well, I had to give notice. And who did I notice? I noticed the North Dakota Attorney General, the North Dakota Superintendent of the Highway Department, the North Dakota Secretary of State, and then the sheriff of the sheriff of my county, okay, and then I'm so sorry. And then the head of the Department of Transportation, all of North Dakota, put them all on notice and said, hey, this is out of your jurisdiction. And so what exactly did I say to them? Well, here's what I said. So my name, a living soul, hereinafter declarant, being of sound mind, competent and authorized by the trust enterprise known as the one that I have, private irrevocable trust, do hereby solemnly affirm and declare the following facts to be true, correct, and complete to the best of my knowledge, understanding, and belief. The undersigned affirms that the conveyance described herein is the property of this type of enterprise, right? Give me a moment. When I bought this truck for the second time, because the state initially actually stole it from me, so I bought this truck as the trustee of this trust enterprise, and so that is what's on the certificate of title that was transferred to me from the previous owner, okay? And I got her to sign a seller's certificate and bill of sale, and I got that notarized, and then I have a certificate of notarization as well, okay? So this thing is part of the lawful owner of this is the trust enterprise, not me, not the ens legis, not the state. And here's how I'm proving that it's not the state anymore, right? Well, the state has the MCO. No, they don't. It's too old of a truck, right? And so how am I doing this? Well, I'm rebutting it with notice, and they are going to agree through tacit agreement, because good luck rebutting this, okay? And so here's what I'm saying to them. So the undersigned affirms that all this is that the conveyance described herein is the private property of the enterprise that I have, a valid and lawfully established trust as evidenced by the certificate of trust filed at the county recorder's office, attached and incorporated for reference. So the trust is the sole owner and holder of the equitable and beneficial interest in the described automobile, and the conveyance described below is the private property of the above referenced trust enterprise, lawfully acquired and held in trust for the benefits of its beneficiaries. And then I go on to describe, the year, make, and model, the VIN number, the color, and then the title number, that certificate of title number, and then I say the seller's certificate, bill of sale attached as Exhibit A, notary's verification on oath or affirmation attached as Exhibit B, and the certificate of title attached as Exhibit C. Okay, and though the manufacturer's certificate of origin is not in the possession of the trustee, the trust asserts legal and equitable title based on lawful private acquisition, exclusive private use, and no voluntary submission to the jurisdiction or commercial registration requirements of the state or any of its subsidiaries. The conveyance is not a motor vehicle as defined in 49 U.S. Code 30102 or in North Dakota Century Code 39-01-01. Okay, so good luck rebutting that it is. Okay, and this conveyance is not used for hire, commercial enterprise, or public transport. It is used solely by the agents and trustees of the trust for private, non-commercial purposes, including private travel, and the exercise of the inherent, unalienable right to locomotion as secured by the First and Ninth Amendments of the Constitution for the United States of America. And this conveyance is not subject to any licensing, registration, or regulatory scheme, and not offered for public transportation. There exists no valid contract, agreement, or delegation of authority to the state of North Dakota or any of its political subdivisions. Good luck rebutting that. Okay, and so the trust enterprise and its trustees and agents formally and lawfully rebut any presumption of jurisdiction by the state or any of its subdivisions or administrative agencies over private affairs, contracts, or property of this trust. And the trust enterprise does not and has not registered the private conveyance with the state, and no application for registration, titling, or licensing has been made to the state by the current beneficial and or equitable interest holder. The trust hereby lawfully and expressly asserts that any prior commercial use or registration has been lawfully terminated and or abandoned by all previous parties. So any record or prior registration by a previous owner does not confer jurisdiction and is hereby rebutted by this notice in the form of an affidavit. This document serves as formal notice that the conveyance described herein is used exclusively for private, non-commercial purposes under a private trust estate, and any presumption to the contrary is hereby lawfully rebutted and revoked in full. Any attempt to regulate, detain, seize, or interfere with the private conveyance shall constitute an unlawful trespass, a breach of fiduciary duty, and a violation of the declarant's and the trust's rights protected under the Constitution and common law. And the constructive notice and public record. While the grantor and beneficiary of the trust enterprise has publicly recorded its beneficial claim to the all capitalized letters name estate via a UCC3 filing in the state of Maryland, securing priority and perfecting interest under common law principles, a certified copy of that record can be produced upon demand. And notice of private markings and USDOT number consists of the trust enterprise through its trustee shall affix to this private conveyance markings consistent with its status as a private motor carrier of private property as defined in 49 CFR 390.5. To that end, the following private use DOT number has been registered and will be prominently displayed. And I typed out what that number is. So, said marking shall appear on plates or panels affixed to the conveyance for the express purpose of public notice and status clarification without granting jurisdiction to the state or any federal agency. And the conveyance is not engaged in commerce, is not for hire automobile, and does not transport goods or passengers for compensation. Its use is exclusively private and familial, consistent with the unalienable rights of travel and property. And so I then affirm that all of that is true to the best of my knowledge, ability, and belief. And I even went so far as to get this thing notarized as a jurat. So we are, that is how I put them all on notice. And then I included a certificate, a cover letter, all of the exhibits that I included, as well as fee schedules, and then of course the declaration of service or the certificate of service. So and included the little green cards, right, to for evidence. Those are witnesses. Those are legal witnesses. So that is the long and short of what I have done to sort of bridge the gap between public and private and help everybody be on alert as far as why I will soon be moving myself and my private property upon the public roadways using private means of conveyance, okay? As well as who is the ultimate liability and the original principal for any debt regarding that name. And I've put everybody on notice. And at this point, should they want to commit another trespass, there is a large amount of things that they would be doing wrong. And then it is subject to the fee schedule that I have recorded. And I do reserve my lawful capacity and equitable capacity to, reserve variability with any of those fees as well. So that is kind of the short and sweet. I know it was an hour. I hope that this was effective for anybody. Please let me know if you want an example of any of the things that I've done here. I'm happy to issue it as a reference material, redacted reference material, not as a template. When we use templates, we aren't self-governing. Okay, and so we need to be handwriting, we need to be creating, we need to be a creator. We are made in his image, we need to be creating. So I'm happy to help with reference material. I'm not going to give you templates. Templates don't, in my opinion, do not work. They're ineffective. They're contrary to self-governance. So that's where we're at. And I hope that this was effective. Thank you so much for stopping by. This has been the Lamb's Reckoning. Next time, we're going to try to figure out how all of this is, how to work the technology here so that we can have panelists and people come in and comment and things like that. So it's not just me rambling. But I hope that this was effective for you. Stay tuned on Mondays for J.W. Shearing to teach us about physical health. Tuesdays for Mike Hill to teach us about equity. Wednesdays for me and Mike to teach about equity with a flavor of consumer law, credit repair. Thursdays with Grant, also known as Chris, and myself to teach about court procedure, how to handle ourselves in statutory court when we find ourselves there, and how to, record things, set ourselves up for proper appealable issues, and how to object and how to handle ourselves in court, whether that's through the mail, whether that's through verbal litigation in person. And so that's happening on Thursdays. And then, of course, Charles, the wonderful Charles Stafford, who is teaching us how to actually defend our lives if the whole world just absolutely is intent on absolutely, threatening our lives, how we can defend our lives using firearm. All right, so and then Saturdays we are oops. Okay, we're gonna try it again. Excuse me. Orange and spherical, got it. Okay, so Mondays health, Tuesdays equity, Wednesdays equity with a flavor of consumer law and credit repair. Thursdays statutory law and all things like legal processes and judicial rules and all those kinds of things, and court rules and rules of evidence and rules of civil and criminal procedure, all that kind of stuff on Thursdays. Fridays, Freedom Fridays, Firearm Fridays, whatever you'd like to call it, Armament Fridays, how to actually physically defend your life with lethal force if necessary. And then it is Saturdays, fellowship with with regard to the Sabbath, right? And then Sundays is like a research day or day off, if you will. Anyhow, thank you so much. This has been the Lamb's Reckoning. Please enjoy whatever fellowship you are able to from this point, and give and receive freely in upliftings from the Father, the Most High, the Heavenly Father above, right? Peace be upon Him, peace be upon you, my brothers and sisters. Thank you so much, and have fellowship on this wonderful Sabbath. Thank you. And Derek, thank you so much, dude. I'll bring you in next time. We'll figure it out. Take care, and God bless everybody, right? All right, thank you so much, everybody. Talk to you soon.